Welcome to Establishment, Modification, and Enforcement of Support in Interstate Cases. Before we begin, we have a few announcements. You'll receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that is included with your certificate. The Family Law section is sponsored by White, Zuckerman, Warsofsky, Luna & Hunt, LLP, and Our Family Wizard. White, Zuckerman, Warsofsky, Luna & Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Their specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. Now on to the program. Well, before we start the program, I just wanted to let you know about a few events that are happening with the Family Bar section, which is actually on fire with all the stuff going on. Sometime in September, we don't have a date, but keep your eyes peeled. At lunchtime, we're going to be doing a program on drafting judgments in family law cases with Brian Lepak and Kendra Thomas. And on October 6th, we're doing a financial program called PP Loans, ERTC Credits, and Other Tax Traps for Family Lawyers, or that family lawyers need to know. That's going to be with CPAs Jack Zuckerman and Avi Reichman, and attorneys Alexander Leiter and Jinna Spatz. So lots of good programs coming up. So on to our program. So the panelists that we have today, I'm very lucky to be able to get them involved. We have Jinna Kang, who's a CFLS and partner at Enenstein, Pham, and Glass. She's a fellow of the International Academy of Family Lawyers. We also have Marshall Waller, a CFLS and shareholder at Feinberg and Waller. He is a fellow of the American Academy of Matrimonial Lawyers and is also a fellow at the International Academy of Family Lawyers. Finally, we have Judge Scott Gordon, former assistant supervising and supervising judge of the family law and criminal divisions of the Los Angeles Superior Court. He's received a lot of awards and is highly recognized as a judge. He is now a mediator and arbitrator in private practice at Signature Resolution. All right, finally onto our program. So first slide, please. So the statute that we're going to be talking about today, you can go to the second slide, actually, that's our title, is the Uniform Interstate Family Support Act. The major points, we're going to be basically just covering the interstate portions of that today. Hopefully in the future, we'll have another program on the foreign country aspects to that statute. UIFSA was enacted in California in 1996 and there's been several iterations after that. The purpose of the statute is that it limits jurisdiction that it can properly establish and modify support orders. So the concept behind it is that multiple states potentially can establish support when it's initiated, when support is first initiated based on the personal jurisdiction over the payor. But after it is issued, then only one order controls. And thereafter, multiple states can enforce it, but only one state may modify it as long as the parties continue to reside in the issuing state. The state also recognizes full faith and credit to other sister states' orders. Now you might be thinking, oh, this all sounds pretty obvious and common sense, but it was not that way prior to the enactment of UIFSA in 1996, and also in particular before the Full Faith and Credit for Child Support Orders Act was enacted in 1994. Prior to that, we had some old statutes that basically did not recognize our sister states' support orders. And, that's the way it was across the country. So you had states all across the country issuing multiple orders that did not necessarily supersede the prior orders. So in effect, you had possibly a bunch of orders where support was accruing simultaneously. This is not so much of it nowadays. Under UIFSA, there are rules in a situation like that to determine which order is controlling. So if you have some of these old orders floating around, keep in mind there are some rules under UIFSA to determine which one would control. Next slide.
And our purpose really is to kind of acquaint you with these concepts of the rules. It's a very technical area, and I think you'll hear throughout the program tonight that when you come up with these issues, we hope to show you the place to go, but always check, double check, because this is a very technical area.
So let me talk a little bit about our next slide, which is the application. Because I didn't want to pay my student loans when I graduated from law school, I went out and I got a tax degree. And reading the UIFSA is a lot like reading the Internal Revenue Code. We're going to be, it's all there. Everything you need to know is in there. But it reads exactly like you would expect something to read that was written by a committee. It's pretty good. It's pretty straightforward. And most of the answers you're going to want, you're going to find in there. It's Family Code section 5700, 1.101 through .905. It's about, 10 or 15 pages. And this establishes the entire scope of it. If you have one of these cases, you need to just pick up the code and read it. We're not really in a position to go over every single point and provision in it, but we are going to highlight the ones that we think are interesting or that you need to know. 5700.102 provides the general definitions. There are a lot of them, and you should read them. It definitely is important to note that. You should also note that UIFSA will apply with foreign orders as well from foreign countries. Not just states. The general bases for jurisdiction. What was intended was to come up with the statutory scheme that was unique and equal everywhere, so that it was predictable and everybody knew what they were going to do. You can establish support with it. You can enforce it. You can even run a parentage action out of this. You can register foreign orders. You can modify certain orders. There are some circumstances under which you can't modify. And there are some special evidentiary rules regarding communications between tribunals. There is some similarity to the UCC JEA, and we can get into that in a little more detail as we go on.
And I think that's just that last point, something that you'll see running through this, the UCC JEA, the Hague, when we talk about it, is the notion, which is really kind of unique to these areas, of the different judicial offices, different tribunals having inter-tribunal communication.
I agree. And Judge Gordon, we were talking earlier about the mechanics of the UIFSA and the various websites that are available. Do you want to speak briefly on that?
There are some very good ones, places that explain it. Los Angeles County Child Support Services Division, and possibly after this, I'll email to Jennifer some of the sites to put them out and supplement the materials. And it was a question I saw about, are we getting the materials? Yes, there's already a link posted up. But they have it. You will also see that if you look at the states that you are looking at, other than California, all of them have a link to their specifics, because even though it's UIFSA, there might be a little bit different in procedure. Also, the California Judicial Council has a very good website on it, and the ABA is publishing good materials on it.
There are a lot of forms to be used with this process, right?
This is a bureaucrat's dream. There are a tremendous number of forms. the one of the things we were talking about is looking at the training that the 1058 or child support commissioners go through. The majority of it is forms. CSSD has people that the Child Support Services Division that specialize in this. There's one individual I think you talked to, Marshall, with foreign. They can assist you, but yes, you have to have the right form. And as we go through, and I think Jenna's going to talk about it, there are some specific things that must accompany whatever you're doing, whether it's a modification, registration, and we'll go through that in a little more detail.
Great. And we can go to the next slide.
So the basic jurisdiction, the first level, is to establish and enforce support. And the concept behind this is, what is the relationship between the respondent, who is the support obligor, and the state? The state has to have personal jurisdiction over the support obligor. And if you go back to law school days, yes, constitutional law is alive and well in family law practice. It relates to the same concepts of being residing in the state, or giving consent to submit to jurisdiction of the state, or being tagged in the state if you happen to be present there and serve there. But then there are other bases as well that relate to long arm jurisdiction, which is based on minimum contacts between a respondent and the foreign state. And those contacts must be of a certain quality, such that the maintenance of the case does not offend traditional notions of fair play and of substantial justice. So there are certain minimal constitutional requirements of due process that are involved in this analysis. And there's a lot of state cases as well as federal cases that talk about that. So Marshall's going to be going into, there's 8 specific grounds that are set forth in the family code that talk about different, in addition to consent and the tag of being, when you're in the state and being tagged, there's about 6 other grounds that are based on this long arm jurisdiction. But not all of it is spelled out, so, there is one default or catch-all provision that allows for any contacts that is consistent with the Constitution. So it's basically your cases that relate to minimum contacts, which have to do with, there's 2 aspects to the analysis: purposeful availment, which has to do with what is the conduct of the respondent in doing activities that invokes that person to, ability to receive benefits and protection of the foreign state. And then you also look at the sufficiency of the relationship, the nexus of the contact. You might remember back from reading some of the cases back in law school about 2 types of personal jurisdiction. There's general and specific. General has to do with when the contacts are substantial, continuous, and systemic, versus specific, which has to do with more specific acts, and the cause of action has to arise specifically out of it. So I'm kind of bringing back concepts from the past, perhaps, but these are, involved in the analysis to the extent that it's, the grounds that you're seeking are not specifically spelled out in the family code.
And this is a different focus, and something very important Jennifer just mentioned. We are used to, counsel in family law is used to the UCCJEA looking at home state, that kind of thing. This is different. And this is looking at not only subject matter, but personal jurisdiction. It can be very factually dependent. And this is where, before you get into this hearing, and Marshall says going to go through some of these 8 specifics, but to really be prepared and develop whatever the evidence is that shows that conduct that you are trying to, or ties that you're trying to establish. But it's a very different focus that we're not used to.
And maybe before we get into the next slide, I'll just tell you a couple of instances, like where courts found insufficient versus sufficient contacts. I'll just give you 2 examples. In one case, a court found insufficient contacts where a non-resident father, whose only contact with California was the support payments that he sent there, his telephone calls to the children and his mother who lived there, and his infrequent child visits to California. The court found that that was not enough to invoke California personal jurisdiction in a child and spousal support matter, and that's Judd versus Superior Court. Whereas another example is in Kang versus Superior Court, KHAN, the court found that a non-resident father who lived in Saudi Arabia for the past 21 years was subject to California personal jurisdiction, where the parties had settled there in California shortly after the marriage, had 2 children in California, owned residence and other real property in California, and the husband maintained a bank account and driver's license. So he had been away from California for 21 years, but he continued to have some contacts there from the past. I'm going to go to the next slide.
So before we get into this in detail, I wanted to circle back to the earlier slide, which is sort of an overview, because I got all tied up with the forms and I found my notes. I know we talked about the things you can do. I just kind of want to stress this. You can establish a support order. You can enforce a support order. You can modify a support order. You can determine parentage under UIFSA. UIFSA does not apply to inter-county matters. It only applies to interstate and foreign country matters. And the remedies are not exclusive. You have all of your remedies, all of your enforcement remedies that are provided under the various codes. You're not limited to this. One of the things I thought was interesting when I was preparing for this is a stranger to the litigation, a grandparent or an employer of an obligor may register a support order and petition for support under UIFSA, which I thought was pretty weird. I actually haven't seen that personally, but I read about it. A non-resident's participation in a UIFSA proceeding does not automatically confer personal jurisdiction. They're allowed to show up and make a special appearance. Telephonic hearings are allowed under the code, specifically under the code. Not such a big deal right now because of COVID, but it was before that. And the California judge can reach out to the other state, like the issuing state, and speak to them and confer with that court to get information and guidance on their laws that might help solve the matter here, which is kind of interesting. It's very similar to the UCCJEA in that regard. For anybody who's on the seminar who doesn't know what that is, that's the Uniform Child Custody Jurisdiction and Enforcement Act. There's no filing fee to start these proceedings. You get to do this for free. And generally speaking, attorney's fees will not be awarded against the obligee or against the enforcement agency. So I thought that was kind of interesting. Moving on to these 8 grounds to establish personal jurisdiction, they are what they are. They're in the code right there. It's kind of interesting to go through them because even though Jennifer indicated that case, the first case she talked about, there's a specific provision in here, number 4, that says, of course, they have to have resided in the state and they provide prenatal expenses or support for the child. The individual is personally served with notice within the state, but bear in mind there's case law that basically says if you're in the state to visit with your child, that's not going to be enough to confer personal jurisdiction. The child resides in the state as a result of the actions of the obligor. That's kind of interesting. If the obligor says, you have to go to California and you have to live there for whatever reason. And by the way, you can stretch this an awful lot to make an argument that personal jurisdiction applies. But if you can convince the judge or the judicial officer that the reason the child is here is because of something the obligor parent initiated or did, then jurisdiction happens.
Or maybe even didn't do, such as abandon the child and the spouse by not paying support, causing them to go back to other family in California or wherever, what other state,
Exactly. One of the more interesting ones, which I've actually seen several times, is number 6. The obligor engaged in sexual intercourse in the state, and the child may have been conceived by that act of intercourse. Now, the most interesting word in that line for me is may. So welcome to California, have all the sex you want, but if a child shows up, you're going to be subject to child support. When it comes to child support, if they can take jurisdiction, they're going to do it. And I think that this is something that a lot of people don't think about. But if you have one of these cases, that's one of the first questions you have to ask is, where was the child conceived?
I think that just to echo something Marshall's saying, on number 5, that the child reside in the state as a result of the direction of the individual. Look to the judgment. If this could be a child support order coming out of a divorce or dissolution decree in another state, look at the entire judgment, because many times part of the I just had a case where part of the stipulated judgment provided that mom and wife would move to California, husband will buy or assist in buying a house in California to promote the visitation. So sometimes the language of the judgment itself will provide that evidence for you. So
anyway, just read these ways in which California can take personal jurisdiction. Bear in mind, you've got all of the other stuff that we learned in civil procedure a million years ago. And
yeah, I mean, notice that item number 8, Marshall. That basically is the catch-all where, anything, that's when you can do that other analysis that regarding minimum contacts.
I've made several very credible arguments against personal jurisdiction and usually lose. The winning part is the subject matter for the most part. That's usually where you're gonna defeat one of these claims if you're opposing it. Okay, we can go to the next slide. And this we just kind of want to, it's not really a comparison so much as an observation. These two statutes are very similar, but they're not. The jurisdiction, as you can see, under the UCCJEA is really based primarily upon the child. It's the child's relationship to the state. And under UIFSA, it's the obligor parent's relation to the state that they're really, really looking at. The concept behind both of these statutes was to provide a relatively streamlined and predictable means of interpretation and enforcement and the satisfaction of certain public policy goals that the courts and the legislature, need to implement. We need to be able to decide where the issue of custody is going to be determined, because there's a lot of conflict in that. And we also need to have a means, a relatively simple means of getting money into the hands of the supported parents and spouses.
And we need to have one controlling order that can be enforced in all the different states.
Exactly.
Don't want the confusion of chaos of those old statutes where there were multiple orders that were all in effect, that were all accruing arrears at the same time.
Right, and that is an interesting thing, because we did have that. It was not at all uncommon. There's now basically a statutorily designated preferential scheme to figure out which of these pre-existing orders are going to be enforced. But anyway, under the UCCJEA, you can't stipulate to jurisdiction, but under the UIFSA you can, which is kind of interesting. There is no forum nonconvenience with UIFSA, but there is with UCCJEA. We don't really deal with home state. It comes up in one context with UIFSA, but for the most part, we don't deal with home state. And
as you mentioned earlier, Marshall, you have the tribunals can communicate with each other in both scenarios, but in UIFSA, it's not required. In UCCJEA, it is a requirement.
That's correct. And probably the most important similarity is the continuing exclusive jurisdiction. It's a concept that's in both of these, and it's there for a reason. And we'll get into that more when Jinna talks about the modification and things like that, because that's a big deal in modifying these orders. And we can jump to the next slide.
Okay, we're going to do a couple of quick hypos. Counsel, let me throw this one out to you, counsel. So husband and wife have no kids. They married in California in 2010. where they live until they both moved to New York in 2015. In January 2021, wife moves back to California. In August of 2021, she wants to file divorce in California and request spousal support. Husband still lives in New York. Can she do it? What do you think, counsel?
Well, she can certainly ask.
That is absolutely true. And what do you think the ruling? What do you think the tentative is?
Well,
I think, yeah, we need to develop more facts here. And certainly this case does not fall within the neat confines of
Correct.
8 grounds under the family code that
Right.
we were talking about. It would be some, just looking at the minimum contacts and the nature and the quality of those contacts.
You would really need to develop the facts, is what we have here. You just do not have enough for personal jurisdiction.
Right. And so dad previously lived in California. He got married in California. The question is, what contacts does he have with California now? The court looks at the contacts at the time that the proceeding is commenced. And so looking at it at this point in time, what is it? Does he still have a driver's license? Does he own any property? Does he vote? Things of that nature.
yeah, assuming the facts that are in here, which are none, then,
Right.
then there isn't going to be any spousal support issues.
Correct. Let's go to the next slide. So whenever you're looking at multiple courts here, you do need to not only look at the specifics of UIFSA or the statute, but look at some of the practical things. You may have, and we'll talk about multiple courts where multiple jurisdictions where you can go through. Personal jurisdiction of a state does continue as long as it has continuing jurisdiction. And that's a term CEJ, continuing exclusive jurisdiction, that we're going to use to modify or continuing jurisdiction to enforce. There can be a choice of law. There's only one state. Remember, that's a theme based on CEJ. And
basically, yeah.
Go ahead.
The state, if there's anything in the original order that cannot be modified under state law, then basically you're stuck. It doesn't matter what state you go to, you're stuck with that. So in the case of child support duration, when it expires, that's always something that's non-modifiable under the issuing state law. So if you start, if your order initially is issued in California, that is the law going forward. No matter where it gets modified down the road, you're still going to be stuck with California law terminating that child support at the age of 18 or 19 if they're still in high school, or under the other circumstances of California law. That still is going to be there. You can't get that modified by another state down the road. So thinking about things like the laws that apply, the substantive law of child support that applies in your case might be a consideration in deciding where to get that initial child support order or spousal support order.
Okay, let's go to the next slide. So just another quick hypo, and just time we'll go quickly through this, but think of some of the 8 factors that Marshall talked about. Mom and dad meet and move in together in California in January 2020. Mom gets pregnant in California in June of 2020.
Ding, 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 ding.
Yeah, exactly. That should indicate one of those, right? And that's not even a may. We have it's pretty clear.
Well, we don't know if it was dad.
Well,
right?
I'm going to assume. They break up in July of 2020. Dad moves to New York. And again, when we used to take tests, things are in there for a reason, and pays for some of mom's medical expenses for pregnancy. Why is that important? Yep. Again, remember it said living in the state and providing prenatal or other support for the child is one of the things that we talked about. Child's born in California in March 2020. In April of 2020 or 21, dad moves to New Jersey. Mom wants to file a paternity action and for support in California. What do you tell her? Jenna, what do you think? Or anybody, any counsel?
Absolutely.
California.
Yeah.
Oh, yeah. So yes, absolutely. California for sure. right?
So,
has
so the
jurisdiction.
interesting question, could they file in New York?
Yes,
Well, go ahead.
I think yes. And
So-
and considering that New York actually gets you child support up to the age of 21, maybe mom wants to file in New York.
So that's an interesting question is, you know, if you can go to the next slide. So you may have, like in New York, as Jen just said, it goes up to 21, it could be there. New Jersey up to 19, so you have those legal considerations, but I'm going to urge you to think about practicals too, right? Nobody lives in New York. You get that New York judge who's got, 40 matters on her calendar, and then walks a case where nobody lives here at all, right? Now, we are in an age where we've got remote appearances, and I think that's going to stay with us. But if nobody's there, you may have to have local counsel, which could elevate the cost of it, right? So even though there's the legal, and I think that's a great point you just made about the age, I'm going to urge you to think about the practicals knowledge too. And do you understand the culture? Because of that child support court. How is it done? What is it done in the practices?
I also, just out of curiosity, I looked up how do you calculate child support in New York and New Jersey, and it's complicated in both states. Regardless of how much experience you have there, it seems like there's a lot of factors and the court has a lot of discretion and there's a lot of gray areas versus in California, we got a formula, that we're going to stick to basically no matter what, except in few, really narrow circumstances. So it's, that could make things a little bit more challenging in those states, especially if you don't have local counsel there.
And you've got to look at it. I mean, you look at the ages compared to 3901 in New York and New Jersey, that could really be an important thing.
It sure could.
I'll go to the next slide.
Simultaneous proceedings. I got to catch up here, figure out where I'm at. Okay, so this is one of those places where the concept of home state does come into play a little bit. And this is essentially what it is. California can take jurisdiction to establish a support order while a similar action is pending in some other state if, and you have to have all of this. So the California action is filed before the expiration of time allowed in the other jurisdiction to file a responsive pleading challenging that state's jurisdiction, and the contesting party challenges the other state's jurisdiction, and California is the home state. And the home state in this context is looked at basically the same as it is under the UCC JEA, which is continuous residence by the child for the period of 6 months leading up to the filing, and temporary absences from the state, do not interrupt. They don't interrupt the 6 months. And that's where home state comes into play here. If the out-of-state proceedings don't address support for whatever reason, then California can do it. So, because technically that's not a simultaneous proceeding. And then the idea is which order prevails. And basically only one support order regarding the same parties is entitled to recognition. And UIFSA, and I mentioned this earlier, UIFSA has a procedure for dealing with multiple conflicting pre-UIFSA orders. And that only applies to multiple child support orders. It does not apply to spousal support orders. With regard to spousal support, it's the Wild West. And so 5700.207, which is part of this simultaneous proceeding scheme, just does not apply to spousal support orders. And we can go to the next slide.
All right, so this is the continuing exclusive jurisdiction that has to do with modifying a support order. This is what makes UIFSA special, and similar to UCCJEA, the terms are both used in both statutes, except under UCCJEA, it's called exclusive continuing as opposed to UIFSA continuing exclusive, but they mean the same. As long as the parties, either of the parties or the child stays in the state that issued that initial support order, that state continues to have jurisdiction. And that's the only state that continues to have jurisdiction to modify. And this is with few exceptions. We'll talk about a few of the exceptions a few slides down, but that's what makes it this UIFSA different from what it was like in the Wild West before it was enacted. And notice that it pertains though to child support. So once everybody leaves the state, everybody has to leave, the child and the parties. And when I say leave, I mean they can't live there anymore. If that happens, then continuing exclusive jurisdiction is gone. And then there's a different analysis to determine what state can modify. But as long as the state still has CEJ, it will be able to modify. Now notice that for spousal support, this rule does not, basically the issuing state is always the one that has exclusive continuing jurisdiction or continuing exclusive jurisdiction to modify. It doesn't matter if the parties leave, it doesn't matter. Basically forever and ever, the issuing state will always have CEJ to modify for spousal support. Important distinction. Next slide.
Okay, again, this is why it's important to listen to wise counsel like Marshall. Mom and dad get divorced in Ohio. Mom moves to California, and this is where the facts get important. One day when dad is visiting with his kids in California, mom serves him with the RFO for modification of child support. Can the California court proceed with modifying dad's child support obligation? What do you guys think?
I think based on these limited facts, no.
And again, all these hypos were going very brief to do a point. I agree, and that's because if as Marshall indicated before, if the only reason you're here is to exercise the visitation.
Well,
now obviously in a real life case, you'd be looking at what is he doing? Is he doing business, everything else?
But actually, no, in this case, because they already have a divorce order. So in that hypo, we're going to assume that when they got divorced in Ohio, they got a divorce judgment.
Correct.
That included a child support order.
Correct.
So that's the issuing state, Ohio.
Correct.
Because dad still lives in Ohio. Correct. Ohio is the only state that can modify.
Correct, which means that California can't.
Right.
Correct. Absolutely correct.
Right. That would be the subject matter aspect of the analysis, and the personal jurisdiction aspect would be California doesn't have personal jurisdiction over.
Correct.
Well, even if he was served validly in California under gotcha jurisdiction, it's still not good to modify.
But gotcha jurisdiction isn't going to apply if he's just in the state visiting his kids.
So which is okay. So I'm going to rule here. Correct. Okay. And just out of time, we're going to move. Next slide.
Okay.
And that's why Judge Gordon is here.
Mindful of people's time.
So these are the exceptions we were talking about to continuing exclusive jurisdiction when we said, a state maintains it until everybody leaves. Well, there are exceptions to that rule. And that's if both parties consent in an international move away situation when one of the parties moves to a different country, and if you're looking to enforce or modify a foreign order from another country here in California. Next slide. So consent consists of two types. Basically, when you have the issuing state, after the parties leave, if the parties agree that the issuing state can continue to be the one with the CEJ, and they make that agreement in the record in the issuing state, then California or the issuing state can continue to exercise CEJ, even though the parties have moved away and the kid no longer lives here. The other situation is when if California still has CEJ, because one of the parties still lives here and another party lives somewhere else, if the parties agree in California, the issuing state, that the jurisdiction's going to move to the other state where the other party moved to, then the CEJ will shift to that new state where the other party moved. So that's another situation. Both of them require consent on the record in the issuing state. Next slide.
Okay, we're gonna have to speed up a little bit because
Yeah.
we're getting tight on time. International move away, basically, it is what it says here. The issuing state or country retains CEJ to modify the order if one party resides in another state and the other party lives outside of the United States. We can jump to the next slide, which is the foreign order modification. This is kind of interesting. It's more interesting I think, to describe how this works rather than going through the specifics of the statute. The United States can modify a foreign support order, but basically it hinges upon whether the issuing country can or will modify their order. And of course, the state still has to have personal jurisdiction over the obligor, which is not that hard to achieve. I recently had a very interesting case where mom and dad lived in Israel, moved to California, moved to New York. Mom moved back to California and then tried to modify the Israeli order. And long story short, you have to have personal jurisdiction. You have to have subject matter jurisdiction. We argued unsuccessfully personal jurisdiction. I think the judge was right when he denied that argument. We argued successfully that there was no subject matter jurisdiction. And it really came down to Israel had not ceded jurisdiction for modification of its order. And so because of that, the judge basically said, they still have it. They haven't ceded it. You know, nobody's gone to court there to get an order from them saying, we don't care what California does with it. And so subject matter was rejected. And so the matter was favorably resolved for our client. And I think that it's important to understand that you just can't modify a foreign order, even if nobody continues to live there. Mm-hmm. They still have that jurisdiction. And 5700-711 is one of the code sections to read in this regard. That references, there's an additional opportunity for California to exercise visitation regarding Hague Convention support orders, which don't come up very often. One of the definitions in 5700-102 says convention means the Convention on the International Recovery of Child Support and Other Forms of Family Maintenance, part of the Hague Convention of 2007. The title alone, proof positive that lawyers wrote that. And it doesn't come up very often, but it does provide an additional opportunity sometimes to grab some jurisdiction. So basically, California is free to enforce the order, but it could not, under those circumstances, modify it. And I think the takeaway on this is that under UIFSA, continuing exclusive jurisdiction is a really big deal. The court that makes the valid child support order retains exclusive jurisdiction to modify it. And as I said, while you can enforce, you can't modify. And I think at this point, we can move on to the next slide and turn this into the Jinna Kang show.
Well, actually, all right, let me just cover this slide. We're almost ready to turn it over to Jinna. But
Sorry, Jinna.
we're gonna just talk about, then you have the situation, finally, when everybody moves out of the state and your CEJ is lost due to the residence of the people, of the litigants. What happens then? Well, then you have two situations. You have, what if the parties move to the same state versus what if they move to different states? So we can go to the next slide. See what happened. Okay. So when they move to different states, then to modify, to get subject matter jurisdiction to modify, the petitioner, which is the person that's seeking the modification, they cannot be the resident of the state. This is key, where the modification is being sought. And the respondent to the modification request has to be subject to the personal jurisdiction of that state. So it's very important that once everybody leaves and the parties are in different states, the petitioner whoever is seeking the modification, it could be the support obligor or obligee, the petitioner cannot be a resident of the state where the modification is being sought. Next slide.
I think it's important to read
Yeah.
5700 611. If you have this situation, just read that code section. It reads like an internal revenue code section, but it's all there in detail.
And in the case where they go to the same state, obviously that state is going to be the one that has jurisdiction to modify. If the parties move to the same state, that's the
So
other
I
situation.
think the information Jinna has really is important. I'm looking at the time.
Yeah.
So I'm going to move through this quickly. The big thing to look at when you go through this type of the materials is think of the word obligor, and which is different, than the other stuff we've used. So we can go, if we have time to come back, I want to get to Jenna's stuff.
Yeah.
So next slide.
No pressure, Jenna, but we did save the best for last.
And this is just something to do with registering an out-of-court order for modification. You have to do it at the same time. The registration has to occur either before or with the modification request.
Right.
Sure.
Which makes sense. Without an order registered, what are you going to modify? So if you have an out-of-state order, either concurrently or first, register it so that you can modify it from then on. Next slide. Interstate recognition and enforcement. Controlling order among competing support orders. The controlling order must be recognized by every state for enforcement and modification. And if there is only one court that has CEJ, that court's order is controlling order, which is logical. If there are more than one court that have CEJ, the current home state order is the controlling order. When you are thinking about, but wasn't UIFSA set up so that we don't have multiple competing orders? Why do we have, how can we ever have this situation where two different courts or even more courts have CEJ concurrently? Well, if you have parties who may file in a foreign country, for example, in Korea, one of the parties may file in Korea, so they may have an ongoing case in Korea. Then the other party may file in California, and California may have jurisdiction over all the matters. So California case would be ongoing. So we have two competing countries, court systems ongoing at the same time. So we could have two CEJ courts concurrently. So in that case, what is the controlling order? If we have competing controlling order issue, then go to first, where is the home state? Where is the baby? Where is the child? And if you don't have a home state order, then you have to go to which one is the latest in time, which one is the most recent order, and that's going to be the controlling order. And if no court has CEJ, then California then can enter a controlling order. Next slide. So registration for enforcement. We talked about registering for modification. So registration for enforcement is covered in Family Code sections 5700.601 through 608, I believe. And 601 tells us you may register an out-of-state court order for enforcement in California. Great. And then you go to 602. This statute tells us what you need to submit to the California court to register an out-of-state court order or income withholding order in California. So notice of registration of out-of-state support order, which is the form FL-570. You have to file that. And you may also have a letter of transmittal requesting registration coming from probably a DCSS-like agency from out of state, and 2 copies, 1 certified of the order to be registered. And you need a sworn statement. This is a statement about if there are any arrears. Yes, I swear I am owed money. Obligor's information, of course, because the court needs to issue an order against the obligor. For example, the social security number, the name, the address, maybe the employer's information. If you have it, the more the merrier. And obligee's information, unless you have a DV sort of an issue and the disclosure of the address or the information of the party or the child or the children should not be made public, then you can exclude obligee's information.
And Jen's absolutely correct with regard to the letter of transmittal. The CSSD agency or its equivalent in the other state can help. And in LA, the 1058 courts deal with those issues.
Right. Family Code Section 5700.603, registered when the order is filed, enforceable in the same manner and subject to the same procedures, shall recognize and enforce, but may not modify. So again, modification was covered by Jennifer and Marshall, and we're only talking about enforcement. So when is it enforceable? When the registration is complete. When is the registration complete? When the order is filed. And I will talk about when the non-registering party can contest and to prevent the registration to finish. Family Code 5700.604, the law of the issuing state or country governs. What does it govern? The nature, extent, amount, and duration of current payments, the computation and payment of arrears and accrual of interest on the arrears, and the existence and satisfaction of other obligations. So just like in modification issues, if you bring an order from New York and you are enforcing in California, and the New York law says the child support goes up to the age of 21. Although you move to California and you're enforcing it here, it will go up to 21. Very good. Next slide. Okay, so this is the non-registering party's right to contest. You are given 20 days after giving notice to contest, and you can seek a hearing to contest this registration. And this is unless the registered order is under 5700.707, which is the convention support order that Marshall briefly talked about. In that case, so in 2007, Hague Convention on the International Recovery of Child Support and Other Forms of Family Maintenance was established. And this is essentially the UIFSA on international platform. And this is sought to establish a modern, efficient, and accessible international system for the cross-border recovery of child support and other forms of family maintenance. In this case, if the registering party is trying to register the Hague Convention order, then the contesting party has 30 days if he or she is in the US, and that person gets 60 days if that person is out of the country. And this Hague Convention, 2007 Hague Convention, became effective in the US in January of 2017. And you can, under this convention, you can request recognition or recognition and enforcement of a decision. Okay, defenses. So the defenses that are available to the non-registering party: one, issuing tribunal lacked personal jurisdiction over the contesting party. Pretty logical. The order was obtained by fraud. Pretty bad, so sure. The order has been vacated, suspended, or modified by a later court order. So I guess it happens more often than we would think, that one party would bring an order from, let's say, New York, and it turns out that order was actually modified in another state, and the contesting party would say, hello, there's another later order, so this shouldn't be enforced. And there is a defense under the law of this state to the remedy sought. Full or partial payment has been made, sure. The statute of limitation under section 5700.604 precludes enforcement of some or all of the alleged arrears, or the alleged controlling order is not the controlling order. Everything makes sense. So next page. And Family Code 5700.608 says, confirmation of a registered support order precludes further contest of the order pretty logical. We don't want to fight over the same thing over and over. Family Code 57000610 may enforce a child support order of another state registered for purposes of modification only if the requirements of 5700.611 or 5700.613 have been met. And those code sections were covered by Marshall and Jennifer, so I will move along. Enforcement of a child support order modified by another state. This is very interesting. So enforcement of arrears and interest accrued before the modification, relief for violations before the modification, recognition of the modification order for reinforcement. So enforcement. So this is talking about a case where it started in California, California issued orders, and then it was moved to another state, and CEJ was taken by another state, and then it came back to California for enforcement. In that scenario, these are the things that California court can do for you. Next slide.
And this slide is actually a restatement, this next slide, of what you just stated, Jinna. So we don't have to go over it. It's the same thing.
Gotcha. So we get to the hypothetical E.
Okay, so what perfect timing, Jen. Thank you. So
Awesome.
counsel, so mom and dad have a paternity action in California, which includes a child support order. Mom and child move to Nevada. Dad moves to Oregon. Dad sends child support payments to Nevada and occasionally visits the child there. Question 1, can the child support order be registered for enforcement in Nevada? What does everybody think?
Can't imagine why not.
What? Absolutely.
Yeah,
Right.
can't imagine why not.
No, no, yes,
Yes.
no. Who
What do
says
you-
yes?
Waller.
Waller said yes.
I don't think that sending, so you're saying his connection, the contact is the payments or the payments.
Well, this is
and
just registration.
this.
Yeah,
Yeah,
this is just for registration.
So this is to enforce, registration for enforcement.
But it's just registration.
Oh.
It's not, it's just registration. There's
So-
multiple steps, but then
What-
enforcement's next, but it can be registered.
So whether mom should do it or not isn't a separate issue, but
Correct.
Right.
Well, is lack of jurisdiction a defense to registration?
So it's a defense to enforcement,
Right.
but it can still be registered. So can the child support order be registered for enforcement and modification?
absolutely not.
Right.
Correct.
Can't
Right.
be modified or enforced in Nevada because Nevada does not have personal jurisdiction over the dad.
Correct. And last, can it be registered for enforcement and modification in Oregon?
Absolutely.
Because as one of the things we talked about, you had a highlighted word of obligor, right? And that's there.
Right.
Correct.
Yeah,
We're done.
we did it. We did it. Yay.
We actually brought it in on time. That's pretty
I did.
incredible.
Thank you, guys.
I don't think we really have time for questions. Let me see if there's anything here. Is there?
Well, there's the one
Well-
question by Keith Clemens and we answered it, actually. We went through.
While
Okay.
Jennifer's looking, I just want to indicate or reiterate to everybody that you can't really even scratch the surface of this subject in an hour. And so our goal was to provide you a reference, essentially. If you've never heard of UIFSA, or if you've kind of heard of it but didn't really know how it worked or what to do with it, we just wanted to orient you so that you'd be able to say, oh yeah, I've heard that. That sounds familiar. I think I can do that. And now you know where to go. It's really not that hard to figure out. You just have to take the time to go through the statutes.
And in today's mobile society, you're probably going to end up dealing with these issues sooner rather than later.
Yeah, I agree. It's definitely going to come up. And before we go, I would also strongly encourage you guys to sign on and watch Judge Gordon's, Jinna's, and Peter Walzer's UCCJEA. It's going to be outstanding. And I can't imagine 3 people better equipped to handle that than those 3. I'm looking
Thank you.
forward to it.
Thank
And
you.
thank you for all your hard work, and Jennifer, for your leadership.
Yes.
Yeah,
well,
thanks,
thank you
Jennifer.
so much. Thank you so much.
All right. I always like to end these with a love fest, and this is fantastic.
Have a lovely evening.
Bye.
Hi, everybody.